So this is about how Louisiana's forced heirship laws force married couples to leave the usufruct of what they have to their spouse. So Louisiana is really the only state that has its unique forced heirship laws. Essentially, it says that if you pass away and you live in Louisiana and you have assets in your name, you've got to leave assets to your children if they're forced heirs. A forced heir is a child of yours who's 23 years of age or younger, or any child, regardless of age, who and they're incapable of administering their own estate. There's a long definition for it. So we're just going to really stick to the 23 or younger forced heirship component. And so what it means is if a person dies and they have kids who are 23 or younger at the time, they got to leave an inheritance to that child or those children who are 23 or younger. If they have one forced heir, they have to leave 1/4 of their estate to the child, the forced heir. 2 or more forced heirs, they got to leave half of their estate collectively to their forced heirs. So really what it means is, in practical sense, is a married person can't leave everything to their spouse. That violates the forced heirship laws. So that kind of simple I love you will that says I leave everything to my spouse violates forced heirship laws, causes problems. And really, parents don't want to just, when the first spouse dies, that couple typically doesn't want assets to go directly to the children then, because that surviving spouse needs those assets to live off of. So, and the married couple typically wants the assets to go to the children after both spouses away. So what do you do? Well, in Louisiana, another Louisiana-only thing is this usufruct, where it does satisfy the forced heirship rules when a parent dies and they leave usufruct to their spouse and they name their forced heirs as what's called the naked owners. Those naked owners get it when the usufruct terminates, typically when that surviving spouse dies. Although in some cases it may say the surviving spouse's usufruct terminates when that surviving spouse either dies or remarries, whichever occurs first. So that's what really where married couples, have to do that to comply with the forced heirship rules, but to provide for their spouse. Yep, they can do it in other ways. They could arrange it where when one spouse dies, that spouse leaves things in trust for the surviving spouse to go back to the children when both spouses pass away. But really, here in Louisiana, typically what we see is people leaving the usufruct of what they have to their spouse, naming the forced heirs as the naked owners. That satisfies the forced heirship rules. Now, certain things that you own aren't subject to the forced heirship rules. Things like retirement accounts, things like life insurance, don't count toward the forced portion or what you have to leave to your forced heirs. So just be aware that, and one other thing, parents who have one child for 23 years, they're not going to be able to leave everything they own to their spouse, at least until that child becomes a forced heir. If there are multiple children, let's say a couple has 3 children over the course of 10 years, then really for 33 years now, they're not going to be able to structure their estate planning program to leave everything to each other. They're going to have forced heirs for a long time, 33 years, if they have children over a 10-year period. So be aware of that. You can really kind of mess things up if you leave things to your spouse and you have forced heirs. So fairly easy if you know what you're doing, and if your estate planning attorney knows what they're doing, to comply with these forced heirship rules. But doing it wrong can really mess things up. So forced heirship forces usufruct. There are some exceptions and some other ways to do it, but be aware of that as you get your legal affairs in order. Take care.